to participate in those advanced stages of the rules moving forward, so that Indiana is better equipped at handling rules once they are then agreed upon and passed. So for our rule decision year, they're also going to have a public hearing. Registration is required to attend the hearing. They're encouraging anyone that would like to speak to attend that hearing. Again, you must register in advance, and they like for you to submit any questions that you may have in advance. A link was provided in the agenda to register for that, and also on the national website is a link to register for the public hearing if you wish to attend. For those rules that have been presented on the table, I like to quickly just go through those. Of all the rules, the compact team recommends that Indiana accepts all of them except for the first one. The first rule, which was based on introducing a new definition for human trafficking, there are no other rules that mention human trafficking. So the introduction of a new rule could cause confusion, holding states to a definition that is not applicable in the rules. So we thought that that was premature. In the event down the road that rules are changed to include specific details about human trafficking, then a definition would be applicable in that situation. So since we don't have those things now, we recommend to turn down this proposal for the definitions. For the rest of the rules, the compact team recommends accepting these changes. For the first one, Rule 4-102, sending and receiving referrals. There are 3 components to this rule. Basically, to clarify that travel permits are required. When reading the rules as they currently are written, it seems that it may be optional, and they want to clarify that any juvenile traveling out of state pending a transfer, the submission of a travel permit is mandatory. So this clarifies that so that no one thinks it's an option, that it's mandatory. Since the change of this rule would mirror another rule, 4-103, the changes in that rule, the minor changes were clerical and to also bring uniformity to the rules. So the second part of those changes is just clearing up the rules so that they all are uniform across the board. The third part of the change to this rule would be moving the word expediting out of the current rule. It'll be stricken because it is at the discretion. The receiving state has the discretion to expedite a home evaluation. It is not mandatory. So with the word expediting written in the rule, it gives the indication that states are required to expedite a transfer. They may do that if they choose to do so to beat that 45-day time frame, but again, that is optional. So this rule would clarify that option. The next rule, 4-103, transfer of supervision procedures for juvenile sex offenders. Again, this mirrors the changes for the last rule, where it indicates that travel permits are required for all juveniles crossing state lines with a pending transfer. That is not an option. The same way it clarifies the language to ensure consistency across the board. The second part of this, the changes to this rule are the same to bring uniformity to the rules. And the third part change of this rule, again, removes the word expediting. The same way it is for regular transfers, it's being made to be consistent with the juvenile sex offenders transferring as well. The next rule, 4-104, the authority to accept and deny supervision. There's 2 parts to the changes. Currently in the juvenile rules, there is no requirement to indicate what conditions a receiving state cannot honor. On the adult side of the rules, that is already implemented. So they want to bring consistency and implement that on the juvenile side, because it's better for the receiving state supervising the juvenile to indicate what they can and cannot provide for that juvenile so that the juvenile is not lost in the system, and they obtain services that are needed. So indicating a forefront that a receiving state cannot adhere to or offer certain services is beneficial to ensure that the juvenile receives necessary services. So we agree to having this added into the rules. It also provides consistency anytime during supervision, and there may be special conditions added to a juvenile's case. It may have started off with a case that those conditions could be met, but at a time during the case, changes may affect the supervision of that juvenile. So we support this rule addition to adding the conditions of supervision that a receiving state cannot meet at the time they accept the transfer. The next rule, 5-103, this was actually a new rule being implemented to change failed supervision to mandatory relocation. As the rules are written currently, a failed supervision often would result in the juvenile being retaken to the sending state. But there was a portion of the rules that indicated if another placement was not available. Since the goal is to continue juveniles in a place where they will be successful, if that is in their home state, that a failed supervision may not result in the removal of the juvenile, but we want to understand that there's a mandatory relocation that is necessary. So this rule will clarify that it is not the desire of the compact to always to remove the child, but seek alternate placement if necessary, and to make it a mandatory relocation, whether that's in the state or out of the state. Also in this rule change language, there will be clerical corrections to provide consistency across the board with all rules. Those are minor changes. And lastly, for this rule, also clarifies that utilizing the failed supervision workflow is mandatory, although it's a mandatory relocation. Initiating that workflow does, again, not mean that the juvenile has to leave the state, but they have to relocate from the current placement, whether it's in a home or with a family member, legal guardian, or they are at school. They have to then now move to a new placement where they will be successful. For the rule 6-102, voluntary return of runaways, probation, parole absconders, escapees, or accused delinquents, and accused status offenders. The main justification in this rule is used to help clarify who's responsible for making return arrangements for a juvenile. Currently, there are two rules that can be conflicting, because one rule states that holding state is responsible for transporting a juvenile to the airport, where the other rule indicates that the home or demanding state is responsible for making transportations. These are two different scenarios. One is transportation home, and one is transportation of the juvenile to the airport to return them home. So some of the language is being stricken from the rule to clarify that it's always the home or demanding state that makes the decision and determines the appropriate measures for the arrangements of returning a juvenile to the home. It is up to the receiving states to assist in transporting that juvenile to the homes, to the means of transportation, whether that's to the airport or whether they're meeting at state lines to assist with the transporting of the juvenile back to their home state. So again, this is for clarification to ensure that everyone understands the home state determines the method of transportation. The holding state assists with whatever method of transportation deemed by the home state. Rule 8-101, travel permits. What this rule does, it clarifies that since the travel permit is mandatory for juveniles crossing state lines, that the travel permit form must be utilized. Currently, sometimes communications are sent that the juveniles are traveling for certain type of offenses. but years ago, Indiana implemented the procedure that all juveniles traveling over 24 hours are required to have a travel permit. So we cleared up any gray areas and confusion where our field would be confused about what type of juvenile receives a travel permit. So all juveniles traveling over 24 hours, and this rule supports that they will not only submit that travel permit, but they will use the travel permit form. This concludes the proposed amendments. And again, the compact team recommends supporting all of the amendments except for the first one for implementing a definition for human trafficking.
Thanks, Nita. Anybody have questions for Nita about any of the proposals? Chris?
Nita, this is very helpful. The only one I have a question about, and it's just a challenging situation, the failed supervision in mandatory relocation. And I'm just thinking out loud, was there consideration to make it more of a judicial decision? Just like, should relocate unless it's in the best interest of the child not to. And it's just, I think, a practical challenge of finding alternative placements. So I just offer that as the only thing I had any question about.
I appreciate that. If I may elaborate, currently, as the rule is written, failed supervision oftentimes results due to the juvenile's behavior. But there are also instances where it's not due to the failed supervision because of behavior, but because the sponsor no longer desires to have the juvenile in their home. For example, they may have been transferred to a grandparent because they can no longer live in the family home because the victim lives in the family home. If the grandparent desires for that youth to be removed from the home for whatever reason, it's not working out, the juvenile may not be successful in that home, whether it's disobedience, for whatever reason, the sponsor has the option to request that the juvenile be removed. So in that instance, the juvenile has not failed supervision per ICJ rules, but it would be mandatory to relocate that juvenile to another place. And so that could be another relative, or maybe they have to make a safety plan and return the juvenile back to their home state. So again, this rule often tends to lean towards those juveniles who are here that has a legal guardian remaining in the sending state, or they may it may be a sex offender who has certain conditions, and now those conditions cannot be adhered to, and we don't want to cause the juvenile to violate their supervision. So these things are to benefit the juvenile when it's not an instance where they have failed supervision because of their behavior. I hope that kind of offers a little bit more insight.
Yes, it does. Thank you, Nita.
I have a question or comment. I understand why human trafficking isn't being inserted since it's nowhere else in the rule, but is there a common practice, since there is such a strong correlation between human trafficking and runaways, that it's part of training or resources or information that's made available for the identification of human trafficking?
Chris, your folks on that.
There is a human trafficking screener that is utilized for youth that are brought in regardless of the nature of the offense. In Indiana.
In Indiana.
In Indiana.
Okay.
There's a box you can check to in the system that says possible human trafficking victim.
But maybe not all regions are doing the assessment for juvenile.
I think Nita can speak on that, but I do know for one of the committees that I'm on, they are trying to develop, making it mandatory that they do the human trafficking screener, but it's a rules year.
Right.
So once the rules change, then they can make a motion to the committee to say, now that the rule has been changed, then this can be mandatory. But
So the rule has to come first
before they.
But the rule is being rejected because it's not anywhere else in.
So for the workflow, so for it to be mandatory in the system, then they have to make sure everything's in place to justify paying the money
Sure.
to fix the system. but I don't, Benita probably can speak more on that, but I do know that it's out there.
Yes, when Unity, the new juvenile system, was implemented, one of the questions that was asked of everyone in the state on end users the question was asked to end users, what type of things would you like to see in the new system? Someone proposed it would be great if we could have a way to initiate states assessing if this was a human trafficking victim. So that was to kind of appease some of those suggestions. So it was implemented in the system, but it was not deemed as a rule. So that's why now the East region requested that human trafficking be put into the rules. So again, the rule would have to come first, and then we would request a coinciding definition so that everyone is agreeing to the same definition of human trafficking. But initially, it was just a suggestion to ensure that states had all the tools they need for their individual state. So states had the opportunity to say, for example, Indiana, we have a human trafficking tool. We would like to know from other states, did you suspect human trafficking? Because this may affect our reports in our state.
The rule that would have to come first would be the rule mandating that you screen.
Right.
Right now, it's just a box in the system, but there's no common definition for what that might mean. Even though there's box in the system, we have our definition, comfortable with our process, but it's not the same across the board.
Yeah, for instance, I know for Maryland, they do human trafficking, but it's also labor human trafficking. So now it becomes very broad, so they're trying to make sure that if we use a definition, it has to be one that everybody can agree upon.
I have a feeling there will be a rule proposed again at some point.
I was gonna say,
Based upon the high rates of
And
human
if the
trafficking.
East doesn't do it, maybe we
Right.
could do it.
Yeah, something to consider.
Yeah.
Thank you.
Any other questions? Oh, sorry, Nita, go ahead.
I believe it's coming down the chain. It's a lot of detail to getting that implemented. So since there are still discussions going on, that wasn't presented with this current set of rule proposals.
Thanks, Nita, I appreciate it.
Anything else for Nita, the staff on these proposals? If not, their recommendation was that the state council support all of the rules except for the proposed rule 1-101. So if that's amenable to anybody, I would ask for a motion in that regard.
So moved.
Second.
Moved and second, any discussion on that? All those in favor say aye.
Aye.
Any opposed? Okay, great. Chris, are you taking those forward to the, okay.
That's correct.
All right, any other business from the state council?
I was gonna note just a couple of things. We are being live streamed, and so if judges watch this, I think they should be aware that if they're transferring folks to Idaho, Idaho has a new law that will affect individuals under probation and parole supervision who come to Idaho after July 1st. And it is the waiver of the Fourth Amendment right to search and seizure. Texas has a new terrorist offender registry, similar to a sex offender registry. So if individuals transfer into Texas and meet a certain criteria, then they will be required to register as terrorists. One last thing is the national training opportunity. If you are interested in attending a training on August 5th from 2 to 3:30, it is about state councils, how to sort of beat them up, make them a bit more useful. I was amazed.
That hurts, Chris.
No. I'm not suggesting anyone here attend.
Well, oh, good.
Yeah, no, and in fact, when I heard this, I think Florida's going to be putting on, and I was thinking, because I'm relatively new to this, and I was like, not everybody has a state council, because it sounded like they were like, hey, if you're ever thinking about doing a state council, we've got this presentation for you. So, no, there was no implication that we could use a brush. Looking at the bearded guy.
I agree,
We're like,
just kidding. Anything else?
That's it.
Did we send the Idaho and Texas updates out to the judges in a message?
We did with the Texas, the Idaho one, I just got it was this week, I think, so yeah, we'll send that out.
Okay, great. Any other business from any of the members? Okay, then the next two meetings are listed there, on the agenda, September 16th and December 16th. If it looks like a scheduling conflict comes up, let Chris know, we'll move those. We always put those in pencil, so. If there's nothing else, I would take a motion to adjourn.
So much.
Okay, that's it. No need for a second, we're adjourned. 12 minutes slower than those IC jamming.
April.